Hello, my name is Shauna Carmichael, the founder of Carmichael Family Law and Consulting, located in Brunswick, Georgia, and serving all of coastal Georgia. I am an attorney as well as an educator, researcher, and practitioner with a background in international studies, law, and conflict resolution. Most recently, I practiced general civil law in Brunswick. Prior to that, I practiced in Massachusetts doing child welfare law. Today I'm going to be talking to you a little bit about child custody, especially important in this time when we're all dealing with COVID-19 and we may be concerned about our health and what might happen to our children if we are not able to care for them. So in terms of child custody, there is one option that is available to you that is pretty easy to do at home if you need it and you want to prepare in case you became ill and could not care for your children. This is called a power of attorney for care of a minor child. This is a legal system created specifically for people to be able to access on their own. You're always welcome to contact an attorney for assistance completing this form, but it is something that's intended to be able to operate outside of the court system and give someone who is a child's caregiver the ability to care for that child properly, to get them medical treatment, to enroll them in school, and to do all of the things that are necessary in order to properly care for that child with the parent's permission. So some of the reasons that you might create a power of attorney for care of a minor child in this situation is you are working in the front line, you're working in a grocery store and a nurse, or you're in a hospital as a doctor, and you're concerned that you might become ill, and if you did, who would care for your kids? So you can create one of these documents in advance, notify, for example, an aunt, an uncle, a grandparent, that's most often who it is, it's a close relative, that you would like them to step in if you're not able to, and then you sign one of these documents that gives them the power to care for your child temporarily, okay? Except for grandparents, the power of attorney only lasts for 1 year. You can renew it after that point, but it's limited in time frame. For grandparents, it can be unlimited. So you complete this document, you sign it, you're not giving up your parental rights. So you remain the parent of the child, you still have input and all of that, and you can cancel it at any time. But this gives the caregiver, your aunt, your uncle, your grandparent, the ability to step in and really take care of that child as needed for however long you are incapacitated. Other reasons that this is used is if a parent is being deployed in the military, if a parent has to have some type of surgical procedure that's going to put them in the hospital for a few weeks or a few months, things of that nature that occur all the time. It's just especially important that we're aware of it now because of this pandemic that we're dealing with. The power of attorney for care of a minor child is authorized by OCGA 19-9-120 through 134. That's just a reference to the actual statute, the law that authorizes individuals to use this form in order to set up an alternate caregiver for their child. That information is not necessary in order to complete the form. It's just a reference in case you want to look it up for yourself, or if you run into trouble when you're trying to use the form with a doctor or a school or something like that, you can give them that reference so they can look it up for themselves and see that it is a valid form of caregiver affidavit. To repeat, the parent or other caregiver for a child can delegate caregiving authority to another relative, and it does have to be a relative. It has to be a grandparent, a great-grandparent, step-parent, a former step-parent, a step-grandparent, an aunt, an uncle, a great-aunt, a great-uncle, a cousin, or a sibling, or something like that, in order to qualify. If it is a non-relative, then that non-relative has to be approved as an agent by a child-placing agency or a nonprofit entity or a faith-based organization. In other words, if you're going to place a child or give someone authority to care for your child who is not a relative, then you have to go through additional steps to have that person approved by some sort of agency. So your neighbor can't be designated as the caregiver using the power of attorney unless they are a relative, just as an example. This is incredibly important because for many of us, if you're a single parent or something like that, it might be that you have to rely on people who are not relatives or close friends or their neighbors. If you're going to do that, you can still write out a document like this. Just be aware that it may not hold water. It doesn't mean that it's not worth the effort to try, just in case that person is going to care for your child and needs to seek medical care or something. But that is not covered under the statute without those extra steps and procedures of getting them approved as an agent. The actual form used to complete a power of attorney for care of a minor child. This example of the form is provided by Atlanta Legal Aid. The statutes that I gave you earlier, the law actually lays out very specifically what has to be included in this power of attorney, so it should be fairly straightforward. Like I said, you can complete it without an attorney, but if you have any questions at all or you're trying to do something a little bit more complicated, certainly contact an attorney for additional advice and for assistance. This example is especially helpful because it includes some of the description I already provided you, some of the facts about who can be designated as a caregiver, who you can give the authority to care for your child. So the person giving the authority has to be the parent or a legal guardian or someone else who has the legal authority to do so. The person that you're giving the role of caregiver has to be an adult, has to be a resident of Georgia, so no sending children out of state to somebody in Florida, or Texas, or Maine, or Connecticut. They have to be a Georgia resident, and the person has to be related to the child. As I said before, a grandparent, great-grandparent, something else of that nature. If the person who's going to be the caregiver is not a relative, they have to be approved by a child-placing agency, nonprofit entity, or a faith-based organization. And also remember that the power of attorney is only good for 1 year or less, and the parent can always go back and cancel it. If you need something that's going to be more long-term, then you should look at guardianship or some other option. Now, when you complete this form, the person who's giving away the ability to care for the child, the parent essentially, has to sign the form, and the individual who is going to be the caregiver has to sign the form. So both people, both the person giving and the person getting the authority to care for the child, must sign the form. And these signatures must be notarized, meaning you have to take the paper in front of a notary and sign it in front of the notary so they can stamp it. Now this part here just goes into some additional details about how the power of attorney works, about situations when it's not appropriate. One major situation where sometimes people want to use the power of attorney but it's not appropriate is if you have a defects case open and that's ongoing. You can't use this to basically avoid defects. Other than that, it's pretty straightforward. If you have some type of medical issue going on, you have some type of family issue going on, something that's taking you as the parent out of the picture for a little while, but not permanently, then you can use this to designate someone in advance of that situation to be the caregiver. The caregiver, as opposed to just dropping your child off with a friend or a family member, this form also puts some more responsibilities, more legal responsibilities on the person who's going to be the caregiver. So the caregiver is required to exercise due care. That basically means use common sense, treat this child that you're caring for like they would be your child. You're not going to do things that would not be in that child's best interest. Now, in addition, be aware that the caregiver can resign, and they can also be removed by a court. So if the caregiver does something wrong, they do something to hurt the child, then a court can remove them. If something happens and a caregiver is no longer able to take care of the child or no longer wants to, then that person can resign. Now, if the caregiver wants to resign, they should notify the parent, because obviously if the caregiver leaves, the child needs to go back to the parent. Somebody still has to be responsible for that child. If there's no one else to take them, then that's when a child could end up in defects or something like that. And as I said earlier, the parent can cancel or revoke the power of attorney. In order to revoke it, to cancel it, you want to put that in writing, notify the person who's the caregiver, and you may also want to notify anyone the caregiver is given the form to. So if your Aunt Susie designate your Aunt Susie as a caregiver, then you have a falling out with Aunt Susie, or you decide she's no longer appropriate, you want to revoke the power of attorney, that's fine. Write out a letter saying that you revoke the power of attorney, give it to Aunt Susie, give it to the school your child goes to, give it to your doctor so they all know that Aunt Susie is no longer authorized to be the caregiver for your child. So here's the form itself. Pretty straightforward. Fill in your name, fill in the name of the child, your date of birth, the name of the person that you're giving the authority to. It's very important that you have an address, phone number, contact information essentially for the person you're designating to be the child. And it's also a good idea to make sure that person has your contact information. And I understand sometimes, if it's a family situation or it's a medical situation, you might get moved. You might start out in one hospital and get moved to another. Make sure you keep it up to date in terms of where that caregiver can contact you so that they can, if there's anything going on, and also make sure that the caregiver understands if they have to move or their phone number changes, they need to let you know as well. You want to spell out, describe how the person you're designating as a caregiver, here it just calls this person the agent, how you know them, how are you related to them. And then you sign it. This is where you are basically swearing. It's like, you're testifying that this statement is true, that this person is either related to you by blood or marriage, and you are not asking them for a background check, or the person is not related to you, option B here, and you have looked at a background check. If you are okay with the background check, there's a conviction or something on it, but you're still okay, but note there. That again is to help protect the child so that either it's somebody that's known to you, that you are familiar with their history, there's somebody who's going to be safe and appropriate to care for your child. And then next place where you'll end up signing is how much authority you're giving to this caregiver. So you can tailor this to your situation and to your needs. You can give all of the power and authority to care for the child to the caregiver, or you can limit it using option B. Now, there are some things that the caregiver can never do. You can't give them the authority to consent to allow your child to be married or adopted or to get an abortion or for parental rights to be terminated. So these are kind of like the major things, huge things that would change the status of a child or be performed on a child. You can't give the caregiver the authority to do that. If you do want to limit it, you select option B, you're going to sign there, and you're going to spell out what authorities you want the caregiver to have or not to have. On this option, you're just going to, on number 6, you're going to initial next to the option you're choosing. Option A makes the power of attorney effective for no more than a year, and you set out the dates when you want it to begin and to end. Option B is if you're giving authority to a grandparent, then you can make it effective indefinitely. Basically, it's good until you revoke it or until you cancel it. Option C is specifically for parents who are in the military and they need to authorize someone for the duration of their deployment. And then these last blanks, this is where you are going to put down your signature, your name, your contact information, and sign this in front of the notary, okay? So the notary can fill out this very last part with their name and seal and stamp it, and it's all official. So that is the basic form. This second part is for the caregiver. So the person who's receiving the authority is going to fill out this part. You're going to put down your name. They're also going to swear and sign by the option saying that, yes, I am related to you or I'm not related to you. They're going to attest that they are not on the state sexual offender registry or child abuse registry, because that would mean they probably aren't appropriate to be a caregiver for a child, that they have provided a background check if you have asked for it as the parent. And basically this is to show that they understand the responsibility they're taking on by being a caregiver, and they're aware of the process and the power, so that you're not getting blindsided essentially with a child, somebody dropping them off for you. The agent will sign here, print their name, and they will do this in front of the notary, and the notary will stamp it and seal and everything, and then it's official. Now at that point, I would recommend keeping a copy. So give a copy to the person who's going to have the power of attorney for care of a minor child, the one who's going to be the caregiver, and then also the parent will want to keep a copy. You can also give a copy to schools, doctors, places like that need to be aware of it. So that is a brief guide to using the power of attorney. Like I said, it's useful in many different types of situations. It's especially important to be aware of it in these current times because of the pandemic and the uncertainty that can cause in terms of when we might be required to go into work if you're in the healthcare field and your shifts might be so long, or you don't want to risk bringing something home to your children, or if you're worried that you're in some other way an essential worker and you're getting exposed, and again, you might get sick and not be able to care for your child. So there's a lot of different reasons you might want to use this, and be aware that this does not impact your ability to parent. It does not change your rights as a parent. You are still the child's primary, important person. You still have all the authority. You're just sharing it so that the person you've designated as a caregiver can also be there for the child when you're not able to. Thank you for watching this video. I hope the information presented has been helpful. If you do have any questions, feel free to contact me. Again, Shauna Carmichael. My email address is scarmichael@carmichaelfamilylaw.com, and my phone number is 912-254-7361. For more information, please click the link in the video description below. Thank you for watching this video. I hope the information presented has been helpful. If you do have any questions, feel free to contact me. Again, Shauna Carmichael. My email address is scarmichael@carmichaelfamilylaw.com, and my phone number is 912-254-7361. For more information, please click the link in the video description below.